On Valentine's weekend in 1998, a young woman named Amy Robinson prepared for what should have been a normal day. At just 19 years old, Amy was described as kind, gentle, and always eager to help others. She lived in Arlington, Texas, and despite the challenges of Turner syndrome, a genetic condition that made her more vulnerable, she was determined to live her life with independence. But tragically, that independence would lead her straight into the path of two men who had already decided that someone had to die. That evening, 18-year-old Michael Wayne Hall and his 23-year-old friend Robert Neville were bored, restless, and filled with anger at the world. In their twisted minds, the solution was simple: kill someone, anyone. Unfortunately, Amy became their target. Lured with promises of a ride to work, Amy willingly climbed into their car. What she couldn't know was that she was being driven toward her final moments. The cruelty that followed was almost unimaginable. Hall and Neville toyed with Amy's life, shooting her with a pellet gun, taunting her, and prolonging her suffering before finally pulling the trigger with a real firearm. Her life ended violently discarded on a lonely stretch of land. The murder shocked Texas and horrified the nation, not only for its senseless brutality, but for the fact that Amy was chosen precisely because she was vulnerable. For investigators and prosecutors, the case became about more than just justice. It became a symbol of how random, unprovoked evil can devastate an entire community. In this video, we uncover the disturbing case of Michael Wayne Hall, the shocking crime, the years of courtroom battles over his mental state, and the final execution that attempted to bring closure to Amy's family. Classification: murderer characteristics, kidnapping, torture, number of victims, one date of murder, February 15, 1998, date of birth, April 6, 1979, victim profile, a mentally impaired woman, 19-year-old Amy Robinson, method of murder, shooting location, Tarrant County, Texas, USA. Status: executed by lethal injection in Texas on February 15, 2011. Hall, then 18, and Robert Neville, 23, went to the Kroger grocery store in Arlington, where their friend and former co-worker, Amy Robinson, worked as a checker. They picked a spot and waited in their car for her to ride by on her bicycle. They had a rifle, a pellet gun, ammunition, and a crossbow with them. When Robinson rode by Hall and Neville coaxed her into their car, promising that they would drop her off at work after taking a short drive in the country. After driving about 12 miles from the store, Neville pretended to have a flat tire and pulled the car over. Hall persuaded Robinson to exit the car. As Robinson walked toward Neville, he fired a crossbow at her several times, all of which missed. Hall shot her in the back of the leg with his pellet gun. He and Neville laughed at Robinson when she cried in pain. Neville then obtained a .22 caliber rifle from the car and shot her in the chest. Hall then shot her in the chest 3 or 4 or 6 times with the pellet gun. Neville then killed her with a shot to the head. They left the victim and her bicycle where they would not be easily discovered, then left. Both men returned to the scene. A few days later, Neville fired shots into Robinson's body, and Hall took keys and money from her pocket. 2 weeks later, Hall's mother reported to the police that he had been missing for several days. Hall's stepbrother told the police that Hall told him he and Neville abducted and killed Amy Robinson. Hall and Neville were arrested while trying to cross the border into Mexico. Robinson's body was discovered the same day. Hall told authorities that he decided to kill someone because he was angry that they had a sucky-ass life. In television interviews after their arrests, the two men bragged about the killing. A tape of the news interview was played to the jury. Accomplice Neville was executed on February 8, 2006 for the capital murder of Amy Robinson in all special meal. Chicken cooked 3 different ways: pizza brownies, sweet iced tea, milk, and vanilla pudding. Last words. I would like to give my sincere apology to Amy's family. We caused a lot of heartache, grief, pain, and suffering, and I am sorry. I know it won't bring her back. He continued speaking, saying he was changed by Christ and was not the same person anymore, and asked for forgiveness. I am sorry for everything. I wish I could take it back, but I can't. Texas Attorney General, Tuesday, February 8, 2011. Media Advisory. Michael Wayne Hall, scheduled for execution. Austin, Texas Attorney General Greg Abbott offers the following information about Michael Wayne Hall, who is scheduled to be executed after 6 p.m. on Tuesday, February 15, 2011. Hall was sentenced to die for the 1998 Tarrant County kidnapping and murder of 19-year-old Amy Robinson. Facts of the crime. Hall was angry with his life, so he and his friend Robert Neville decided to kill someone. On Feb. 15, 1998, Hall and Neville saw 19-year-old Amy Robinson riding her bicycle to a grocery store in Arlington, where she worked. The 2 men offered Robinson a ride and took her to a rural field in Fort Worth. Hall and Neville got out of the car and walked into the field, while Amy waited in the car listening to the radio. At some point, Hall persuaded Amy to get out of the car, and Hall shot her in the back of her leg with his pellet gun. Hall and Neville laughed while Amy cried in pain. Meanwhile, Neville returned to the car and got his .22 caliber rifle and shot Amy in the chest. Hall then shot her in the chest 3 or 4 or 6 times with the pellet gun. Amy fell to the ground making loud noises and shaking. Hall stood over her and stared for 5 to 10 minutes. Then Neville shot her in the head, killing her. Neville was executed on February 8, 2006 for the capital murder of Amy Robinson. Punishment-related evidence. At the sentencing phase of his trial, the parties introduced evidence regarding Hall's level of intelligence. Friends, family members, and some teachers testified that Hall had difficulty in school and had difficulty with simple daily tasks. The state introduced evidence suggesting that Hall was not mentally challenged, but was rather lazy, depressed, and difficult to motivate. For its part, the trial court noted that motions Hall had prepared and filed himself were well drafted. Hall had no prior convictions. Procedural history. March 24, 1998. A Tarrant County grand jury indicted Hall for capital murder. February 17, 2000. A Tarrant County jury found Hall guilty of capital murder. Feb. 23, 2000. After a punishment hearing, the court sentenced Hall to death. January 16, 2002. The Texas Court of Criminal Appeals affirmed Hall's conviction and sentence. January 17, 2002. Hall filed an application for state habeas corpus relief. March 13, 2002. The Texas Court of Criminal Appeals denied Hall's request for a rehearing. October 7, 2002, after Hall appealed to the United States Supreme Court, the court vacated the judgment and remanded the case to the Texas Court of Criminal Appeals for further consideration in light of Atkins v. Virginia, which barred the death penalty for the mentally retarded. February 26, 2003, the Texas Court of Criminal Appeals adopted the lower court's recommendation and denied Hall's application for relief. May 5, 2004, in connection with the appeal on remand from the Supreme Court, the Texas Court of Criminal Appeals, taking notice of the retardation-related evidence developed at trial and in state habeas corpus proceedings, again affirmed the judgment. June 20, 2006. Alleging that he was mentally retarded and thus exempt from the death penalty, Hall filed a petition for federal habeas corpus relief. August 3, 2006, a Fort Worth, U.S. District Court denied Hall's petition for habeas corpus relief. June 30, 2008, the United States Court of Appeals for the Fifth Circuit vacated the judgment of the lower court and remanded the case for an evidentiary hearing to determine whether Hall was mentally retarded. March 9, 2009. After conducting a live hearing to determine whether Hall carried his burden of showing that he was mentally retarded, the U.S. District Court determined that Hall had not carried his burden and denied relief. February 22, 2010. The United States Court of Appeals for the Fifth Circuit denied Hall permission to appeal. April 4, 2010, the Fifth Circuit Court denied Hall's petition for a hearing by the full court. In 2010, the United States Supreme Court denied Hall's petition for certiorari review. John 18, 2011, the Fifth Circuit Court denied Hall's motion to recall its mandate. Associated Press, February 15, 2011. Huntsville, Michael Wayne Hall, convicted in the 1998 torture slaying of a 19-year-old mentally challenged Arlington woman, apologized profusely Tuesday, minutes before he was executed. Hall, 31, received a lethal injection less than an hour after the U.S. Supreme Court refused to stop his punishment for the abduction and murder of Amy Robinson. Hall was pronounced dead at 6:23 p.m. at the Huntsville unit of the Texas Department of Criminal Justice. The other man convicted in Robinson's death, Robert Neville, was executed in 2006. I would like to give my sincere apology to Amy's family, Hall said as he was strapped to the death chamber gurney. We caused a lot of heartache, grief, pain, and suffering, and I am sorry. I know it won't bring her back. Speaking just above a whisper, his voice shaking and eyes watery, the Arlington man said he wasn't the same person and repeatedly asked for forgiveness. Relatives of his victim stood a few feet away looking through a window. I am sorry for everything, Hall said. I wish I could take it back, but I can't. 9 minutes later, he was pronounced dead. Robinson's sister, Amanda, refused to forgive him and said she attended the execution Tuesday night so her face would be the last face Hall saw. It was fake. He wasn't sincere, she said of Hall's apology. He was really scared. You could tell. I just don't think he was remorseful. What about the pain he caused Amy? I'm glad the execution was on Feb. 15, but it should have been a lot sooner. Hall was executed 13 years to the day Robinson was killed. They turned a bad day into a good day, said Ruth, another sister. I feel like a weight's been lifted off my shoulder. Target practice. Lawyers for Hall argued that he was mentally impaired and ineligible for the death penalty under a Supreme Court ruling that bars capital punishment for those with an IQ under 70. Mr. Hall's history of mental retardation reaches back to his childhood, attorney Bryce Benjet said in his appeal. Hall's lawyers went to the Supreme Court a day after the Texas Court of Criminal Appeals, the state's highest criminal court, refused to stop the punishment. Similar appeals also failed in other courts. Hall was 18 when evidence showed that he and Neville, a 23-year-old paroled burglar, decided to abduct and kill Robinson, who worked at a Kroger in Arlington. The men had been fired from jobs at the same supermarket. Robinson had a rare genetic disorder called Turner syndrome, which occurs only in women and is characterized by short stature and lack of sexual development at puberty. Prosecutors described her as mentally challenged and trusting. Authorities said Hall and Neville stopped Robinson along the bike route they knew she took to work and offered her a ride. She accepted. They drove her about 12 miles to a remote area of Tarrant County where Neville shot at her repeatedly with a crossbow but missed. They also shot her numerous times with a pellet gun and a .22 caliber rifle, prosecutors said. Target practice, they bragged to reporters after they were arrested 2 weeks later trying to cross into Mexico near Eagle Pass. They also told reporters how they laughed as Robinson pleaded for her life. After their arrests, Neville told the Star-Telegram that he and Hall wanted to become serial killers whose victims were minorities. Robinson was part American Indian. "We had a bet going to see who could shoot and kill the most people between the two of us," Neville said. Hall said they returned to her body a few days later and took her keys and $4 or $5 from her pocket. Then he and Neville shot her several more times. A limited existence. In an interview last week, one of Hall's trial lawyers, Bill Harris, said he believes that Neville was the person who killed Robinson and cooked up the whole scheme. "I'm personally convinced Michael is mentally retarded, that he fits the classic definition," Harris said. "If you got to know Michael for very long, you got to understand he was pretty profoundly limited. Half the time, he didn't remember my name." Harris said that even if Hall was moved from death row to the general prison population, life would not be easy. "People with his mental limitations frequently are targets of some abuse and can be taken advantage of by other prisoners," he said. At least 4 other Texas inmates have executions scheduled in the coming months. Timothy Wayne Adams is set to die next week for fatally shooting his 19-month-old son during an argument with his estranged wife in Houston. February 15, 2011, as he lay on the gurney in the death house in Huntsville Hall, 31, made a lengthy and tearful last statement in which he apologized to the family of Amy Robinson, his victim, and to his family, and asked for his family's forgiveness. "First of all, I would like to give my sincere apology to Amy's family. We caused a lot of heartache, grief, pain, and suffering, and I am sorry." Weeping, Hall also spoke of his faith in Jesus Christ. "Even though I have to die for my mistake, he paid for mine by wages I could never pay. Here I am, a big, strong youngster crying like a baby. I am man enough to show my emotions, and I am sorry. I wish I could take it back, but I can't. I can't take it back." Before his execution, Hall asked to watch the 2004 movie The Passion of the Christ, but prison officials were unable to locate a rental copy. For his last meal, Hall ordered chicken cooked 3 different ways: pizza brownies, sweet iced tea, milk, and vanilla pudding. The victims' sisters, Amanda and Ruth Ann Robinson, and 2 of the victims' friends, witnessed the execution along with 2 friends of the condemned. The lethal doses of sodium thiopental, pancromium, bromide, and potassium chloride were administered to Hall at 6:14 p.m. He was pronounced dead at 6:23 p.m. The pair, 23-year-old Neville and 18-year-old Hall, drove her to a remote spot 12 miles away, where Neville shot her with a crossbow and Hall fired on her with a pellet gun. Neville finally shot Robinson in the head with a rifle to stop her from making noises that he feared might attract attention, according to testimony. They returned to her as yet undiscovered body, stole a few dollars and her keys from Robinson's pocket, and fired on the body several more times. Both men, after having lost their jobs at the supermarket where their victim worked, decided to kill someone, they told reporters, and intended to target minorities, killing as many people as they could. Anybody as long as they weren't our color, Neville told the Fort Worth Star-Telegram after Robinson's slaying. Robinson was part American Indian and suffered from Turner syndrome, a rare genetic disorder characterized by a lack of sexual development at puberty, which made her easy prey, prosecutors said. Neville and Hall bragged to reporters during jailhouse interviews soon after the crime, making fun of Robinson for begging for her life before they killed her. Prosecutors played a videotape of Hall describing the murder. He talked about the killing of this young woman, the way a kid might talk about having the toughest football team, kind of braggadocio. And matter of fact, said Bill Harris, who represented Hall at his trial, I watched the jury. You could see the door slamming shut. From standpoint of a human being, I can understand. Hall's lawyers claimed he was mentally impaired and heavily influenced by the older Neville, whom he admired. At his execution 5 years ago, Neville also apologized to Robinson's relatives and his parents. There are 4 more executions scheduled so far in 2011. 3 of the condemned inmates were convicted in Tarrant County, 1 in Harris County, and 1 in Bayne County. 18-year-old Michael Wayne Hall and his friend Robert Neville decided to kill someone because Hall was angry that he had a sucky-ass life. They started searching for the right victim and preparing for their crime by obtaining rifles, pellet guns, a crossbow, and ammunition. After much looking, Hall and Neville finally chose 19-year-old Amy Robinson, a friend and former co-worker, because she trusted them, and they didn't have to put bruises on her to get her in the car. The evidence also revealed that Amy had a genetic disorder that made her small and mentally and physically slow. She stood 4 feet 5 inches tall and had the mental capacity of a 3rd or 4th grader. On February 15, 1998, Hall and Neville went looking for Amy in order to carry out their murderous plan. They checked her schedule at the Kroger grocery store and then lay in wait for her to ride by on her bicycle on her way to work. When the pair saw Amy, they coaxed her into the car, promising to drop her at work after they circled around in the country. As Neville drove, Amy complained that she did not want to be late for work. Neville then pretended to have a flat tire and pulled the car over on a dirt road by a remote field. Hall and Neville got out of the car and walked into the field carrying their weapons, while an unsuspecting Amy waited in the car listening to the radio. At some point, Hall persuaded Amy to get out of the car, telling her she needed to go talk to Neville near a tree. As Amy walked toward Neville, he fired a crossbow at her several times. Neville missed each shot, but Amy became angry when the last arrow grazed her hair. When Amy started walking back to the car, Hall shot her in the back of her leg with his pellet gun. Hall and Neville laughed while Amy cried in pain. Meanwhile, Neville returned to the car and got his .22 caliber rifle. When Hall managed to maneuver Amy back into the field, Neville shot her in the chest. Hall then shot her in the chest 3 or 4 or 6 times with the pellet gun. Amy fell to the ground making loud noises and shaking. Hall then stood over her and stared for 5 to 10 minutes. The pair worried that someone would hear Amy, so Neville shot her in the head, killing her instantly. Hall and Neville then left Amy and her bicycle in an area where they would not be easily discovered. A few days later, they returned to the scene. Neville fired shots into Amy's dead body, and Hall took keys and money from her pocket. When Amy's family and co-workers realized she was missing, a massive search ensued. More than 2 weeks later, authorities focused on Hall and Neville. Fearing they would be caught, the pair fled Arlington, but were soon arrested when they attempted to cross the border into Mexico. The authorities found Amy's body on the day of the arrest. Michael Wayne Hall, 31, was executed by lethal injection on 15 February 2011 in Huntsville, Texas, for the abduction and murder of a 19-year-old woman. After driving about 12 miles from the store, Neville pretended to have a flat tire and pulled the car over on a dirt road by a field in East Fort Worth. Hall grabbed a pellet gun, Neville took the crossbow, then they both got out of the car and walked into the field while Robinson stayed in the car and listened to the radio. At some point, Hall persuaded Robinson to exit the car, telling her she needed to go talk to Neville. As Robinson walked toward Neville, he fired a crossbow at her several times. All of his shots missed, but the last arrow grazed her hair, making her angry. As she started walking back to the car, Hall shot her in the back of the leg with his pellet gun. He and Neville laughed at Robinson when she cried in pain. Neville then obtained a .22 caliber rifle from the car and shot her in the chest. Hall then shot her in the chest 3 or 4 or 6 times with the pellet gun. Robinson fell to the ground, making loud noises and shaking. Hall stood over her for 5 to 10 minutes watching. Neville then became concerned that someone would hear the loud noises Robinson was making, so he killed her with a shot to the head. They left the victim and her bicycle where they would not be easily discovered, then left. That day, a store employee called Robinson's family to notify them that she had not shown up for work. The family then called the police, who questioned Hall and Neville. Neville told the police that he used to work with Robinson and knew her socially, but had not seen her in a couple of months. A few days later, Hall and Neville returned to the scene of the killing. Neville fired shots into Robinson's body. Hall took keys and money from her pocket. 2 weeks later, Hall's mother reported to the police that he had been missing for several days. Hall's stepbrother told the police that Hall told him he and Neville abducted and killed Amy Robinson. Hall and Neville were arrested in Eagle Pass on 3rd March while trying to cross the border into Mexico. Robinson's body was discovered the same day. Hall told authorities that he decided to kill someone because he was angry that they had a sucky-ass life. He and Neville began obtaining weapons and decided upon a victim. They initially wanted to kill a black person, but they chose Robinson because she trusted them and they didn't have to put bruises on her to get her in the car. Robinson, who was part Native American, also suffered from Turner syndrome, a genetic disorder that made her physically small and slow and mentally retarded. She stood 4 feet 5 inches tall and had the mental capacity of a 3rd or 4th grader. In television interviews after their arrests, the two men bragged about the killing. Hall boasted that he was the one who persuaded the victim to trust them and that she would have escaped had Neville tried to kill her by himself. When asked how he felt about the way Robinson died, he expressed no remorse but said, "Well, I wouldn't want to be in her place. She had to take a lot of pain." Hall also told the media that he and Neville wanted to become serial killers and kill 1 to 5 people per week. They also wanted to become white supremacists and kill minorities. "We had a bet going to see who could shoot and kill the most people between the two of us," Hall said. "No matter if it was blacks or Mexicans, anybody as long as they weren't our color." Hall had no prior criminal history. At his trial, there was some discussion of his mental capacity. Several defense witnesses testified that Hall had difficulty in school and in performing simple daily tasks such as counting change or cutting meat with a knife. Tamara Campbell, Hall's former supervisor at Kroger, testified for the state that Hall was lazy but not mentally challenged. Witnesses from both sides agreed that Hall's writing and math skills were on an elementary school level, but that he could read well enough to pass his driver's license test, and he had no difficulty communicating verbally. Cheryl Connor, one of Hall's teachers in high school, testified that he was inattentive in class and would sometimes drool, fall asleep, or simply sit and stare. On the other hand, Connor and other witnesses testified that he was good at tasks. He was motivated in such as playing video games. A tape of Hall's interview with Fox 4 News was played to the jury. A jury convicted Hall of capital murder in February 2000 and sentenced him to death. The Texas Court of Criminal Appeals affirmed the conviction and sentence in January 2002. In June of that year, the U.S. Supreme Court ruled that executing mentally retarded prisoners was unconstitutional. In October, the Supreme Court ordered Texas to review Hall's death sentence in light of that ruling. A Texas State District Court held a hearing regarding Hall's mental retardation claims. In December 2002, the court ruled that Hall was not retarded. The Texas Court of Criminal Appeals affirmed this finding in February 2003 and again in May 2004. In the latter hearing, the appeals court noted the trial court's discussion of a pro se motion Hall prepared and filed himself asking for his attorney's removal. In an ex parte hearing outside of the prosecuting attorney's presence, Judge Cook commented that Hall's motion was well drafted and that he could name some attorneys that can't draw an instrument any better than this right now. Cook advised the defense that the document would damage their trial strategy if the state discovered it. The case then went back to the federal courts. A U.S. District Court denied Hall's appeal in August 2006, but then in June 2008, the U.S. Fifth Circuit Court of Appeals ordered the District Court to hold an evidentiary hearing regarding Hall's mental retardation claim. After conducting a live hearing, the District Court ruled in March 2009 that Hall had not proven that he was retarded. Hall appealed from there to the Fifth Circuit and Supreme Courts again, but this time they denied his appeals. Robert James Neville Jr. was also convicted of capital murder and sentenced to death. He was executed in February 2006. He apologized for the murder in his last statement and asked for forgiveness from both the victim's family as well as his own parents. "I would like to give my sincere apology to Amy's family," Hall said in his last statement. "We caused a lot of heartache, grief, pain, and suffering, and I am sorry. I know it won't bring her back." He continued speaking, saying he was changed by Christ and was not the same person anymore, and asked for forgiveness. "I am sorry for everything," he concluded. "I wish I could take it back, but I can't." The lethal injection was then started. He was pronounced dead at 6:23 p.m. Two of Robinson's sisters, Amanda and Ruth, witnessed Hall's execution. "It was fake. He wasn't sincere," Amanda said of Hall's apology. "He was really scared. I just don't think he was remorseful." Ruth said, "They just turned a bad day into a good day. I feel like a weight's been lifted off my shoulder." Hall Vrian State 67 SW3 870 text.crim.de app 2002 direct appeal. Defendant was convicted in the 371st District Court, Tarrant County, Sharon Wilson J. of capital murder and sentenced to death. On automatic appeal, the Court of Criminal Appeals, Kiesler J. held that one evidence was legally sufficient to support the jury's finding at punishment stage that defendant would continue to be a threat to society. Two reporters were not acting as state agents when they conducted interviews of defendant. 3, danger of unfair prejudice in admitting tape did not outweigh its probative value. And 4, infliction of death penalty did not constitute a violation of due process and cruel and unusual punishment. Affirmed. Kiesler J. delivered the opinion of the court, joined by Keller P.J. and Myers, Womack, Hervey, and Cochran J.J. Michael Hall was convicted of capital murder and sentenced to death. FEM1 direct appeal to this court is automatic. FN2 Hall raises 13 points of error, including a challenge to the sufficiency of the evidence supporting the jury's finding on the Article 37.071, Section 2 job punishment issue, FN3. We find Hall's claims meritless and affirm the judgment of the trial court. FN1, Text Penal Code, and Vira 19.3a, Text Code Crim. Procas Art 3771 or 2G. Unless otherwise indicated, all references to articles refer to the Code of Criminal Procedure, FN2. Art 37.071, Para 2H, FN3. See Art 37.71, Fire 2B. Statement of facts. 18-year-old Hall and his friend Robert Neville decided to kill someone because Hall was angry that he had a sucky-ass life. They started searching for the right victim and preparing for their crime by obtaining rifles, pellet guns, a crossbow, and ammunition. After much looking, Hall and Neville finally chose 19-year-old Amy Robinson, a friend and former co-worker, because she trusted them and they didn't have to put bruises on her to get her in the car. The evidence also revealed that Amy had a genetic disorder that made her small and mentally and physically slow. She stood 4 feet 5 inches tall and had the mental capacity of a 3rd or 4th grader. On February 15, 1998, Hall and Neville went looking for Amy in order to carry out their murderous plan. They checked her schedule at the Kroger grocery store and then lay in wait for her to ride by on her bicycle on her way to work. When the pair saw Amy, they coaxed her into the car, promising to drop her at work after they circled around in the country. As Neville drove, Amy complained that she did not want to be late for work. Neville then pretended to have a flat tire and pulled the car over on a dirt road by a remote field. Hall and Neville got out of the car and walked into the field carrying their weapons, while an unsuspecting Amy waited in the car listening to the radio. At some point, Hall persuaded Amy to get out of the car, telling her she needed to go talk to Neville near a tree. As Amy walked toward Neville, he fired a crossbow at her several times. Neville missed each shot, but Amy became angry when the last arrow grazed her hair. When Amy started walking back to the car, Hall shot her in the back of her leg with his pellet gun. Hall and Neville laughed while Amy cried in pain. Meanwhile, Neville returned to the car and got his .22 caliber rifle. When Hall managed to maneuver Amy back into the field, Neville shot her in the chest. Hall then shot her in the chest 3 or 4 or 6 times with the pellet gun. Amy fell to the ground making loud noises and shaking. Hall then stood over her and stared for 5 to 10 minutes. The pair worried that someone would hear Amy, so Neville shot her in the head, killing her instantly. Hall and Neville then left Amy and her bicycle in an area where they would not be easily discovered. A few days later, they returned to the scene. Neville fired shots into Amy's dead body, and Hall took keys and money from her pocket. When Amy's family and co-workers realized she was missing, a massive search ensued. More than 2 weeks later, authorities focused on Hall and Neville. Fearing they would be caught, the pair fled Arlington, but were soon arrested when they attempted to cross the border into Mexico. The authorities found Amy's body on the day of the arrest. Sufficiency of the evidence at punishment. In his 6th point of error, Hall claims that the evidence presented at trial was legally insufficient to support the jury's finding that he would be a continuing threat to society. FN4. In reviewing the sufficiency of the evidence at punishment, we look at the evidence in the light most favorable to the verdict. We determine whether any rational trier of fact could have believed beyond a reasonable doubt that Hall would probably commit criminal acts of violence constituting a continuing threat to society, FN5. The facts of the crime alone can be sufficient to support the affirmative finding to the special issue, FN6. Additionally, we have consistently defined society as encompassing both the prison population and the free population, FN7. FN4, see Art 37071, 2E1, FN5, Jackson v. Virginia, 400. US 307-99 SCT 278161 LAD 2D 560-9079 Aldridge v. State 850 SWW 2D 471 Tex Crime App 9091 Cert denied 510 US 831 114 SCT 101 126 LED 268 1993 FN6, Aldridge, 850 SWW2D at 488 FN7. C. Griffith, v. State, 983 SWW2D 282 288 N 9 Tex Crim App 1998 Cert denied 528 US 86 120 SCT 77 145 LED 2D at 6 of 1999. The facts of this case support the jury's affirmative finding that Hall would continue to be a threat. The evidence did not show a hastily conceived murder plan, but a methodical, premeditated scheme. In addition, once Hall and Neville had made their plans and chosen their mentally challenged victim, they taunted and tormented her, reveling in her confusion and agony. Finally, Hall boasted in his media interview that he was the one who got Amy to trust him, and she would have escaped had Neville tried to commit the offense without him. Indeed, Hall told the media that he had no remorse for Amy's death. When asked how he felt about Amy dying the way she did, Hall snickered, "Well, I wouldn't want to be in her place. She had to take a lot of pain." After his arrest, Hall told law enforcement and the media that he and Neville had wanted to become serial killers and kill 1 to 5 people a week. They also wanted to become white supremacists and kill African Americans. In addition to the facts of the crime and the circumstances surrounding Hall's arrest, the state presented evidence that Hall told one of his teachers about violent fantasies he had about injuring others. Hall also admitted to the defense psychologist that he had violent demonic bloody dreams, which the psychologist testified was common for potential killers. The state's psychologist testified that there was no indication that Neville had duped Hall into committing this crime. A rational jury could reasonably have concluded that Hall would continue to be a threat to society given the facts of the case and the psychological evidence. Accordingly, we hold the evidence legally sufficient to support the jury's affirmative answer to the future dangerousness issue. Point of error 6 is overruled. Admission of videotape statement. In his first 5 points of error, Hall claims that the trial court erred in admitting into evidence a videotape statement he gave to reporters. Specifically, in his first 2 points of error, Hall complains that the admission of this statement violated both due process and the effective assistance of counsel under the 5th, 6th, and 14th Amendments to the United States Constitution and Article 1, Sections 10, 14, 19, and 29 of the Texas Constitution. Hall offers no reason for construing the Texas Constitution as conferring greater protection in this area of law than the federal Constitution. Therefore, we will not address his state constitutional arguments. FN8 Hall also fails to distinguish between his rights under the 5th Amendment and those under the 6th Amendment, so we will assume that Hall had been formally charged at the time of the media interview, and we will combine our analysis of these points. FN8, see Muniz v. State, 851 SWW2D 238 251 252 text.crime app 9093 cert denied 510 US 837 114 SCT 176 126 LED2D 82 1993 Heitman v. State 815 SWW2D A1 60991 N23 text.crim app 9091. In Maine v. Moulton FN9, the United States Supreme Court re-emphasized that after the initiation of formal charges, the Sixth Amendment guarantees the accused the right to rely on counsel as a medium between the state and the accused. This guarantee includes the state's affirmative obligation not to act in a manner that circumvents the protections accorded the accused by invoking this right. The Sixth Amendment is violated when the state obtains incriminating statements by knowingly circumventing the accused's right to have counsel present in a confrontation between the accused and a state agent. FN10. FN9. 474 U.S. 159. 106 106 SCT. 477 88. LED.2D. 481 1985. FN10. ADE. During a pretrial hearing on a motion to suppress the complained of statement, the television reporter who conducted the interview testified that she and a television photographer went to the sheriff's office early that morning and talked to deputies about her desire to interview Hall and his co-defendant. The sheriff was not in the office at the time, so they were told to come back later. When the two returned shortly before lunch, the sheriff informed the reporter that her request would be presented to Hall and Neville and that she should check back later. A Fort Worth newspaper reporter and a newspaper photographer were also at the sheriff's office at that time and made a similar request to interview the suspects. When the television reporter and photographer returned to the office, a deputy came out holding a note which he indicated was a signed consent to the reporter's request for an interview. But the reporter stated that she had not written such a note. Upon request, she then wrote a note to the suspects with her request for an interview. A deputy took it to them and told them that they could sign the request or not. Both signed. It is not clear who generated the first written request. The two reporters and the two photographers were directed to an interview room with a counter and fencing separating them from the suspect's seating area. Neville and Hall were then interviewed separately. Both reporters testified at the hearing that no authority ever suggested that they conduct the interview, nor did authorities suggest any questions for them to ask the suspects. Both reporters also testified that they did not provide authorities with copies of their resulting interviews. We find no evidence that the authorities prompted the interview. We conclude that the reporters were not acting as state agents when they conducted the interviews, and Hall's rights were not violated when the evidence was presented at trial. Points of error 1 and 2 are overruled. In his third point, Hall argues that the trial court erred in admitting the videotape because it showed him in a cage and therefore reversed his right to be presumed innocent under the Due Process Clause of the federal and state constitutions. But Hall did not object on this basis at trial. To preserve a complaint for appellate review, the record must show that the complaint was made to the trial court, FN 11. Here it does not. Hall's third point of error is overruled. FN 11, text.r app, P33.1. Hall claims in point 4 that the prejudicial effect of the tape clearly outweighed any probative value the tape might have had in violation of Texas Rules of Evidence 401 and 403. The trial court has broad discretion in conducting a Rule 403 balancing test, and we will not lightly disturb the decision rendered. FN 12. C. E.G. Moreno vs. State 22 SWW 3 4482 489 text.crim.app May 99. In this case, the videotape's probative value was that it allowed the jury to see Hall's behavior and hear his rendition of the facts of the offense firsthand. These are also the factors which make the evidence prejudicial. But we find that the videotape simply reflects the reality of the crime committed and Hall's lack of remorse. In short, the prejudicial effect of this evidence comes from nothing more than what Hall himself has done. He cannot successfully say, "You must not be outraged by my outrageous behavior." For otherwise relevant evidence to be excluded under Texas Rule of Evidence 403, the record must show that the danger of unfair prejudice substantially outweighs the probative value of the complaint of evidence. This videotape, though prejudicial, was not unfairly so. The trial judge did not abuse his discretion in overruling Hall's objection. Point of error 4 is overruled. Finally, on this issue, Hall complains that a duplicate version of his videotape statement that had been edited by the Tarrant County District Attorney's Office was not properly authenticated under Texas Rule of Evidence 11003. The rule provides that a duplicate is admissible to the same extent as an original unless a question is raised as to the authenticity of the original, or in the circumstances, it would be unfair to admit the duplicate in lieu of the original. Hall argues that the edited copy of the tape had been created in a manner that was orchestrated for the greatest theatrical effect, and that the questions and the order of the answers from the original tape were changed. The edited version of the tape was admitted into evidence at the guilt-innocence phase of the trial, while an unedited version of the tape was admitted into evidence at punishment. During the pretrial suppression hearing, the television reporter stated that she watched the entire taped interview as it was being duplicated. She testified that the unedited duplicate tape accurately reflected her memory of the interview with Hall, which she had personally conducted. The television reporter also stated that she had watched the edited tape, and except for some portions of the interview being deleted and other portions being rearranged, it also accurately reflected the events of the interview. Although the newspaper reporter had not participated in the copying or editing of the videotape, he also testified that both tapes accurately reflected what had occurred during the live interview. After viewing both tapes, we find no evidence that Hall's statements were taken out of context or substantially altered in the edited version. The only portions of Hall's interview excluded from the edited tape concerned information about his family, his future plans with Neville, and statements about an extraneous bad act. Much of this information would have been inadmissible at the guilt-innocence stage of the trial. Furthermore, Hall never attempted to admit the remainder of the tape into evidence under Rule 106, FN 13. The judge did not abuse his discretion in admitting the tapes. FN 14. Point of error 5 is overruled. FN 13. See text.r, Evid 106. FN 14. Text.r, Evid 1003. See also Ladd v. State 3 SW 3D 547 571 Text Crem App 99 Cert Denied 529 US 1070 120 SCT 1680 146 LED 487 2000. Constitutionality of death penalty and Article 37.071. In his 7th through 13th points of error, Hall complains that Article 37.071 is unconstitutional or operates unconstitutionally as to him for a variety of reasons. Specifically, Hall asserts in his seventh point of error that Article 37.071 gives the jury too much discretion and insufficient guidance to avoid the improperly capricious imposition of the death penalty. This court has consistently decided this issue adversely to Hall's position. FN 15, point of error 7 is overruled. FN 15, C, e.g. Raby v. State, 970 SW2D 17 Tex Crim.IAP 998 Cert. Denied 525 U.S. 1003 119 SCT 500 42 L82D 427 1998 Pondexter v. State 942 SWW2D 5 and 8687 Text.Crim.App 996 Cert. Denied 522 U.S. 825 118 SCT 85 139 L82D 42 97. In points 10 through 13, Hall argues that the mitigation question included in the death penalty statute unconstitutionally limited the jury's consideration of the mitigating evidence and otherwise failed to adequately guide the jury in considering the evidence. FN 16. This question is a statutory codification of the dictates handed down by the United States Supreme Court in Penry v. Linaw, FN 17. We have previously held this provision to be constitutional, and Hall has presented no new arguments here. FN 18, points of error 10 through 13 are overruled. FN 16, C, Art 37071, Mar 2E, FN 10, 492, U.S. 302, 109, SCT 2934, 106, LED 256, 989, FN 18, C, Shannon, Vita State 942, SWW2D 591, 598, Tex Crim.App 996. In his eighth and ninth points of error, Hall asserts that it is a violation of due process and cruel and unusual punishment to inflict the death penalty on the mentally retarded. In arguing these 2 points, Hall does not distinguish, nor does he provide authority distinguishing between his due process rights and the prohibition against cruel and unusual punishment included in the Eighth Amendment. We will likewise answer the 2 issues together without distinction. FN 19, C, Text RAP, P 38.1H. We note that the United Supreme Court has granted certiorari twice this year on the issue of whether the Eighth Amendment prohibits the imposition of the death penalty of the mentally retarded. On September 25, 2001, the Supreme Court dismissed as improvidently granted the writ of certiorari granted in McCarver, North Carolina. FN 20. The case of Atkins, Virginia, FN 21 is still pending. FN 20. 533 U.S. 975, 122 SCT 2022, 150 LED 2D 804 2001, FN 21. 533 U.S. 976, 122 SGT 24, 150 L80 805 2001. Hall argues that his cognitive abilities necessarily reduce his culpability to such a level that the assessment of death is a disproportionate punishment. In support of his point, Hall points out testimony from his own expert clinical and forensic psychologist, Dr. Mark Cunningham, who testified that Hall was mildly retarded and generally functioned at the level of an 8 to 10-year-old child. Hall then notes that Texas law does not allow the execution of children who are 8 to 10 chronological years old, and in fact does not even prosecute children of that age. Thus, he argues, the law should not allow the execution of a person with the mental age of a child. The United States Supreme Court answered this question in Penry when it addressed whether it is cruel and unusual punishment under the Eighth Amendment to execute a mentally retarded person with Penry's reasoning ability. FN 22. The Supreme Court reasserted the principle that punishment should be directly related to the personal culpability of the criminal defendant and defendants who commit criminal acts that are attributable to a disadvantaged background or to emotional and mental problems may be less culpable than defendants who have no such excuse. FN 23. Indeed, the court agreed that mental retardation has long been regarded as a factor that may diminish an individual's culpability for a criminal act. FN 24, however, the court could not conclude that all mentally retarded people, by virtue of their mental retardation alone, and apart from any individualized consideration of their personal responsibility, inevitably lack the cognitive, volitional, and moral capacity to act with the degree of culpability associated with the death penalty, FN 25. In other words, mentally retarded persons are individuals whose abilities and experiences can vary significantly. And although retarded persons often have difficulty learning from experience, some are fully capable of learning working and living in their communities. FN 26. In light of these diverse capacities and life experiences, the court concluded that it could not be said that all mentally retarded people by definition can never act with the level of culpability associated with the death penalty. FN 27. FN 22. Penry 492 U.S. at 313. FN 23. Penry 492 U.S. at 319. FN 24. AD at 337. FN 25. Penry 492 U.S. at 338. FN 26 ID FN ID at 338.30. The principle set forth in Penry applies with equal force today. Although Hall presented evidence that he generally functions at the level of an 8 to 10-year-old child, the jurors were required to consider this evidence only in light of all of the evidence presented. So long as the sentencers could consider and give effect to mitigating evidence of mental retardation in imposing sentence and make an individualized determination whether death is the appropriate punishment. In this particular case, the Eighth Amendment does not preclude the assessment of a death sentence. FN 28. See Penry 492 U.S. at 340. The jurors not only had Dr. Cunningham's assessment that Hall functioned as a child, but they also had his concession that Hall would be considered only mildly retarded. Furthermore, the jury had the testimony of the state's expert, Dr. Randall Price, who was not convinced that Hall was retarded. Instead, Price testified that Hall could be mildly retarded, but he also might be of borderline intelligence. Price further noted that in his professional opinion, Hall functioned more in the adolescent to young adult stage. Additionally, persons who had worked with Hall at Kroger testified that he did not appear mentally challenged, just lazy. Finally, the jury was able to observe Hall's behavior firsthand in the videotaped interview he gave the press. FN 29. See also Ex parte Tenard 960 SW2D 5760-63 text.cram app 97 cert. Denied 524 U.S. 956 118 SCT 2376 141 LED2D 743, 1998. In light of this evidence, we cannot say that Hall's due process rights have been violated or that he has been subjected to cruel and unusual punishment. Points of error 8 and 9 are overruled. We affirm the judgment of the trial court. Price, Johnson, and Holcomb, J.J. concurred in the result. Hall v. Texas, 537 U.S. 802, 123 SCT 70, 2002, remand. On petition for writ of certiorari to the Court of Criminal Appeals of Texas, motion of petitioner for leave to proceed in forma pauperis and petition for writ of certiorari granted. Judgment vacated and case remanded to the Court of Criminal Appeals of Texas for further consideration in light of Atkins v. Virginia 536 U.S. 304 122 SCT 2242 153 LED 335 2002. The story of Michael Wayne Hall is one of cruelty without reason. At just 18 years old, he and his friend Robert Neville decided that boredom was enough justification to take a life. Their victim, Amy Robinson, was not chosen because of anything she had done, but because of her vulnerability. She was young, trusting, and living with a condition that made her an easy target for predators. For Amy's family, the pain never truly ends. Her dreams of growing into adulthood, of building a future, were violently stolen in a moment of senseless brutality. Hall's execution in 2011 may have closed the legal chapter, but it could never erase the loss. This case forces us to confront uncomfortable questions. How can someone so young commit such monstrous acts? Does the death penalty truly deliver justice? Or does it only highlight the darkness of human nature? As we remember Amy Robinson, we are reminded that behind every headline is a real person, a stolen life, and a family left to grieve forever.